Okay. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of how to get divorced pro se. My name is Nia Murray. I am Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also joining us today is Ms. Myra Hippolyte with the City of Houston's Department of Neighborhoods, and our other partner includes the Harris County Appraisal District, Harris County Tax Assessor Collector's Office, Lone Star Legal Aid, the Earl Carl Institute, Houston Volunteer Lawyers, and Houston Bar Association. And on behalf of the Houston Bar Association, our presenting person here today is Ms. Angela McKinnon with the Harris County Domestic Relations Office. So she's going to be providing you guys with the information on what you need to know about divorce pro se and the new services that are offered, or the new program that is offered through Harris County Domestic Relations Office. Let me kind of give you guys a quick little background really quick about A Month of Service. The Month of Service is a collaboration of these 8 different organizations that have come together to provide information and resources to the community relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We started doing these programs collectively several years ago, because we pretty much service the same community. We have the same mission, the same goals in mind, and that is to provide information and resources to a lot of those folks in a lot of underserved communities that do not have access to this information, don't know about it, don't know where to go whenever they need assistance, who to reach out to, and so on and so forth. We used to be in the community in person doing these presentations, but of course, due to COVID, we've had to adjust and adapt, and we did not want to stop doing what we were doing. So we've transitioned to I was about to say domestic platform, but to a virtual platform in providing this information to the community. This platform has allowed us to reach a greater number of people throughout the state of Texas, and even sometimes in other states and other countries that join us online or via Facebook. So we know that there's a need. We know that there's still a whole lot more people, again, that do not have access to this information, and we wanted to make sure that we were doing our service and providing this information to the community. Let me just kind of give a couple little disclaimers here. The information that is provided here today is for informational purposes only. It is not to be construed as legal advice. However, we do encourage you to reach out to our legal service partners if you are interested in receiving or interested or have a need for any civil legal services that is offered through these different organizations. And Ms. McKinnon is also going to be providing some information and resources to further assist you in the efforts of getting a divorce pro se. So with that being said, please keep in mind that we are interactive. We would like for you guys to be as interactive as you possibly can. Feel free to ask whatever questions that you like. However, we want to try to protect your privacy as much as possible. So please keep in mind, we are recording this session, and we are also broadcasting live on our social media platform at Amos Houston TX on Facebook. So if you're joining us from there, please feel free to type your questions into the comment section or type your questions into the chat, and we will review all questions at the end. Or feel free to unmute yourself and you can ask your questions directly of Ms. McKinnon. So again, when you're asking your questions, keep in mind, please do not say my ex-husband or soon to be ex-husband XYZ and we live at blah blah blah. Please don't provide us with that information. So just keep that in mind. Also, for any of our legal service presentations that we do where you see a course number, on behalf of the Houston Bar Association, they are sponsoring CLE credits for attorneys that are watching this presentation and that participate in the A Month of Service programs. So if you see a course number there, please know that you are able to receive free CLE credits. We're working on real estate CLE or CE credits, but we're going to get there. We're not quite there yet. So we've had people to reach out and ask us about that. So we're working on that still too. But with that being said, please feel free again to ask whatever questions that you like. We know that you guys, you know, you're going to receive a lot of information here today. So again, we are recording this session. We will be sending out a link so that you can go back to watch the recording or to share with someone else that may find this information to be beneficial as well. Or you can also go back to our Facebook page and watch the recording there, or as well as our YouTube channel. So with that being said, thank you guys for joining us this afternoon. We're going to go ahead and introduce our partner and our presenter, and we will move right along into the presentation. So Ms. Myra.
Thanks, Ms. Nia. Thanks, Ms. Angela. Good afternoon. My name is Myra Hippolyte, and I work with the City of Houston Department of Neighborhood under the direction of Manager Paul Green. On behalf of Mayor Sylvester Turner and Director Takasha Francis, we want to welcome you to the Month of Service collaboration. This partnership is all about giving back free information to the Houston, Harris County, state of Texas community. We want to make sure that you know that whenever you're going through a stressor in your life, that you know you've got a team of partners that are here to walk right by your side and give you as much free information as we can, so that when you're going through that stressor, you don't just automatically say, oh my God, what do I need to do? Now you go step one. Okay, what is it that Miss Angela said? Step one, step two, step three. What was it that Miss Nia said when I had to call an insurance agent? What if I'm talking to an insurance attorney? What if I'm going through a hurricane? What am I supposed to do to make sure I'm safe, my family's safe? That's what the month of service is all about. But one of the things is we can walk by your side, but it takes you to take one step, and it's to come in and watch and join the virtual workshops for free. Guess what? They're all free. It's not about you, me, how much it costs. Every single virtual workshop is free. So guys, thank you so much. Have a great time. And Miss Angela, I am so ready to take notes and get ready to get educated. Thanks, everybody.
All right, Ms. Angela, thank you again. You're on mute.
All right, thank you, everybody. And I want to first thank A Month of Service for allowing me to speak on this subject, because this is a subject that's pretty close to my heart, I will have to say, because our office actually does a lot of work in the self-represented litigants field. And so this right here, divorces in particular, I'm sure it can be a very cumbersome process, a very stressful process. And if there's one less thing that you have to worry about, which is getting the paperwork together and knowing what to do in order to get your case started. And that's what we're here for. And so thank you again for allowing me to come out and speak on this project or this subject. Okay, so without further ado, getting started, I'm going to go ahead and share my screen so that we can go through the presentation together. All right. Are we able to see this? My screen here?
It's coming up. Not yet. It says that you're started to share. Yep, now you're good.
All right, perfect. There we go. All right, so divorces for pro se litigants. Again, my name is Angela McKinnon. I'm one of the staff attorneys with the Harris County Domestic Relations Office. And again, we do have a self-represented litigant project or program through our office where we review some of the orders for the parties. All right, so as far as our agenda is concerned, the first thing that we're going to cover, let's see if we can move along here. What to do to get started, notifying the respondent, children issues, property issues, answering to your divorce, what to expect in court after you've answered your divorce or in order to finalize your case, and then some of the resources that you can use following today in order to get the information you need or move along in your process if necessary. So what to do to get started. Who are the parties, what to file, and where to file, who, what, and where. As first to get started, you have your petitioner. You can't have the case get started without your petitioner or a plaintiff in civil cases. That's the person who presents the petition to a court, officer, or legislative body. Those are the persons that file the original divorce petition with the court. And then you have your respondent, who is the opposing party in legal proceedings that begin with a petition, the person against whom the action or relief is prayed, or who opposes the prayer for that petition. And so you have your petitioner or plaintiff in a civil case, or the respondent, which is the opposing party, or in a civil case that would be referred to as a defendant. What to file? In order to get your divorce case started, I can't tell you how many times I've actually had that question posed to me when I'm reviewing these pro se litigant cases or moving forward with things like that. You have to file your original petition for divorce. In divorce cases, you either have an original petition for a divorce with no children, or you have an original petition for divorce for a case that does have children. And if you go to texaslawhelp.org, there's so many resources on that website that the parties can use, starting with your original petition. They do have those forms available for you. And so you don't have to go to the library and try to research how to get a document, a legal pleading like your original petition drafted, because the forms on Texas Law Help, which is what you see here, have all the legal information and arguments that you need in order to present that claim to the court. And so if you look at the petition itself, it has the information on discovery levels, the legal notice, jurisdiction, which you'll have to prove in your case, who the parties are, when you got married, and when you actually got separated. And so if you're using the legal petitions on texaslawhelp.org, you want to make sure that you're using the most updated petition itself. You always want to make sure that you're using the most updated forms, because I can't tell you how many times we have parties that go into court, they file their cases and they get kicked back because the judges are looking at them and they're expired forms. And so as you're seeing here, I'm going down on the form. It has everything that you need. You just have to fill in the box. And another issue that we see with parties filling in these petitions and these forms is you have to make sure you fill it out completely. There may be sections that don't apply to you or don't apply to your case, but you want to make sure that you're either putting NA for not applicable or unknown if the information is unknown. Don't just skip it, because you want to make sure that the court is aware that you are looking at the petition fully and you have addressed each section in your petition. And so here you see you have a divorce petition without children as well. And you know, Texas Law Help has gotten pretty progressive actually. And so we have petitions for divorces for opposite sex parties with or without children. They also have petitions for same-sex parties because we have those same-sex marriages in Texas now. And so we have on Texas Law Help all of the forms that you would need in order to get your case started. In your original petition, this is really if you're trying to draft the petition on your own, there's certain things that you need to make sure that are included. You want to make sure that the heading of your petition is correct in the matter of the marriage of whatever the parties are. For instance, for my name, Angela McKinnon, and the responding party. And so that's going to be the heading for your case. You will get a cause number for your case, which is the number that's referenced in court for your particular case itself when it's initiated. You'll get that number when you file your case with the district clerk's office. And so you'll also get a court that's assigned, a case that your case will be assigned to a court. So you'll get a court number at that time as well. A petition in a suit for dissolution of marriage, which is a divorce petition itself, is sufficient without the necessity of specifying the underlying evidentiary facts. And so what that means is that you don't have to go into detail in your petition itself as to the reasons for why you're getting your divorce or why you're pursuing your divorce case. In fact, Texas is a no-fault state. And so you really, you don't have to list any grounds at all. Some people do choose to list grounds in their original petitions, for instance, adultery, cruel treatment. Sometimes those things come into play, they become important when you're trying to divide property. But for purposes of your petition, you don't necessarily have to list specific evidence, evidentiary facts, and you may not even want to, because you want to understand that when you file in these documents with the court or the clerk's office, they're going to be made public. And so any information that you don't want to be made public, that's private information, you certainly want to leave off of your petition itself. The petition shall also state the name of the parties and their residences. You want to put the full name of the party, your full name, and the respondent's full name as well. And the original petition, for divorce shall also contain a short statement of the cause of action. sufficient to give fair notice of the claim that's involved. And this is really any petition that you file, not just specific as to divorces itself, but in any petition, original petition itself, you want to make sure that it includes whatever your cause of action is. A statement that the damages are within the jurisdictional limits of the court, and a demand for judgment. Demand for judgment is just whatever you're asking for. In a divorce case, you're asking for your divorce to be granted. You may also be asking for the court to make decisions concerning the children, you know, whether or not there's child support assessed in your case. And so you want to make sure that information is included in your petition. Again, if you're using the documents on texaslawhelp.org, that information is already going to be included. You just need to fill in the information that's specific to your case, right? So that's the original petition. So where do you file? Where do you file your petition? So jurisdiction defined. We have this thing called jurisdiction in the legal world. If you're not used to the term, it's the power and authority constitutionally conferred upon or constitutionally recognized as existing in a court or judge to pronounce the sentence of the law or to award the remedies provided by law upon a state of facts, proved or admitted, referred to the tribunal for decision, and authorized by law to be the subject of investigation or action by that tribunal. And so whichever court actually has the authority to make the decision for what you're asking for in your petition itself. The general residency rule for a divorce suit, which is what we follow in our cases, which is how we know what court to actually file your case in. And so for purposes of a divorce case in Texas, a suit for a divorce may not be brought in the state of Texas unless at the time, and this is how we calculate these times. So at the time that you're actually filing your petition, you have been domiciled in the state of Texas for at least 6 months, and you have been residing in Harris County or whichever county you're filing your petition in for at least 90 days. 90 days from the date that you're actually filing your petition, not 90 days or 6 months from the date that your case is finalized. And so that's what we're looking at when you're filing your petition. Where are you residing? However, if there's one party that's residing in the state of Texas, you still may be able to file your petition here if you can prove to the state or prove to the court where you're filing it, that is, it's a correct court for that case to be pending in. And so for a non-resident respondent, which is a respondent who lives outside of Texas, if the petitioner is a resident of Texas, at the time the petition is filed, the court may exercise personal jurisdiction over that non-resident respondent, which is the person that's living outside of Texas. If Texas was the last marital residence for the petitioner and the respondent, and that's the 2-year anniversary of that date on which the marital residence hasn't ended, basically. So the 2 years hasn't passed since the other party has moved outside of the state of Texas. That's if the marital residence is located here in Texas. However, there's also a catch-all statute that Texas Family Code also includes. And so if there's any other basis, basically, within the Constitution of Texas and the United States for the exercise of personal jurisdiction, then the court can still exercise it. You know, and so, you know, if you can establish that there's some sort of minimal context, maybe there are, you know, the children here, maybe the party has been going back and forth, maybe the children, if there are children involved in the case, were conceived here in Texas, you know, and so those are reasons that you may be able to still get jurisdiction where there's a non-resident respondent involved in your case. So notifying the respondent. How do we notify the respondent? And so you got your petition filed, right? You've gotten your case started. How do you notify the petitioner? Because the reality is that in our courts, or any courts, is that you won't be able to move forward with the case until the respondent has been properly notified. And by properly notified, you're either going to have that person sign a waiver of service. A lot of times, if the case is uncontested, meaning if it's an agreed case, the responding party won't mind signing a waiver of service. Texas Law Help, and I'm going to be using Texas Law Help a lot because, again, this is a wonderful resource for pro se parties. So Texas Law Help does have waiver of service forms available, whether you're doing a divorce with or without children. And so the waiver of service form, it looks like this. This is the form itself actually for divorce with children. And as you can see, this form actually has some instructions. And a lot of times people just kind of, breeze by these instructions, but they're really important because if you don't follow these instructions, you may be, filing a waiver that's not valid, which means that you're going to have to go back and redo it all over again once your case is actually filed. And so what I've seen in the past is I've seen parties have a waiver of service executed by the respondent before or even the same day that their petition is filed. And in a case like that, that waiver will not be deemed valid. Okay. And so that party will have to have that waiver re-executed, because if you see very bold here, instructions to the respondent, do not sign it until at least 1 day after the original petition for divorce has been filed. And there's a reason for that. If you look at the waiver itself, there's certain language in here. The language specifically says, I have been given a copy of the original petition for divorce filed in this case. So if you have a situation where the waiver of service is filed on the same day, it could very well have been done after the divorce was filed, even if it is on the same day. But how is anyone supposed to know that? And so for that reason, it needs to be done at least 1 day after. That way it can be easily determined that this is a valid waiver. In addition to that, there's certain things in this waiver, certain information in this waiver that needs to be completed by the responding party. I've seen waivers of service where, incomplete information, they don't include an address. If there is a social security number or a driver's license number, you certainly do need to include just the last 3 digits. You don't have to include the full numbers, because again, once you file these documents with the clerk's office, they're going to be made public knowledge. So you don't want to put your full social security number or driver's license number on there, but you do want to put your contact information. You do want to check whether or not you served in the military. And if you are trying to get a name change through this divorce, you need to check whether or not you're doing that. Most importantly, these waivers need to be notarized. There is one exception, obviously, if you're incarcerated, we have a respondent that's incarcerated, that responding party may not have a notary available. And so they can certainly file what's called an unsworn declaration, where they're still swearing under penalty of perjury that the information that they're providing in this waiver of service is correct. Another reason why you want to make sure that you're filling out your address and contact information in these waivers is because this may be the information that the courts are using in order to send you a copy of the final decree once those final decrees are signed off by the judge. Now, something else about this waiver of service is that it's not what's called a global waiver of service, because this one, the ones that are listed on texaslawhelp.org, let's see where it says. I understand that by signing this form, let's see, I am entering an appearance in this case. And this waiver of service should be asking for, let's see, there it is. I ask that the court not enter any orders in this case unless the order is signed by me or unless I have received prior written notice of the date, time, and place of hearing. Now, parties don't necessarily have to use the waivers of service that are on texaslawhelp.org. Again, like I said, this isn't what's considered a global waiver of service. When I say a global waiver of service, what I'm referring to is waiver of service that's filed and that says I'm entering my appearance for all purposes. You're not asking for a notice. You're not asking for the court to, decline signing off on an order if it doesn't also have your signature. And so if you are presented with, if you're a responding party and you're presented with the waiver of service, you certainly want to make sure of whether or not this is a specific waiver of service as just, waiving the necessity of the service itself, because if you're a responding party, you're entitled to personal service. Or if this is a global waiver of service that allows the petitioner to move forward and finalize your case without you being notified prior to that. All right, so certainly pay attention to that. And so it's been a long it's long been the Texas law that a waiver of service or of process may not be made prior to the initiation of the lawsuit. And that's what we just covered. And so we want to make sure it's listed in case law, it's listed on the waiver of service form itself is very important, because you don't want to get into court thinking you can finalize your case and realize, uh-oh, I can't do anything until I execute a waiver of service. And unfortunately, sometimes what happens is we'll be able to find the responding party in the beginning stages of the case. And so you'll try to get them to sign off on things when you can communicate with them. And then later on, they may not be found. And so then you're kind of stuck, without any service, without a valid waiver of service. And so you want to make sure that you're doing it right the first time around. All right, and so again, the waiver of service must contain the mailing address of the party who executed the waiver. So the Texas law forms already has those blocks for you to enter that information in. However, if you're, drafting your own waiver of service, which you very well may do, if you're drafting your own waiver of service, you certainly want to make sure that that information is in there, because you don't want your waiver of service to be deemed insufficient, because we have seen that in court as well. So again, the waiver of service must be sworn to before a notary public and that's also important too. So sworn to before a notary public who is not also an attorney in the case, and so which it certainly has happened in the past before, where you have an attorney who is representing a party in the case, signs or notarizes a waiver of service, or even a party who is also a notary tries to sign or notarize a waiver of service, and that isn't appropriate. And so you need to have someone who has no interest in the case, a notary who has no interest in the case, notarize your document. And so one other important thing you need to understand about the waivers of service is that you need to actually sign, physically sign the waiver itself. The courts or the Texas law does not allow the parties to execute digital signatures. You know how you can go on DocuSign and get an electronic signature on your documents. That's not something that's going to be appropriate for a waiver of service. You need to actually have the respondent physically sign in the presence of a notary, unless they're incarcerated, in which case they can certainly do a unsworn declaration under penalty of perjury. So if you have a party who is not a respondent, who is, not willing to sign a waiver of service because they're not required to, that's, usually in cases where it's an agreement, an uncontested case where there's no real arguments as to how the case is going to be resolved. But if you have a case where it's probably going to be contested, you're going to have to get the other party served. The first thing you need to do is to request the service. And certainly there are fees involved with requesting that service. In Harris County has their own form. Each county has their own form to request service. And so for purposes of this presentation, I'm using Harris County because that's where we are located. But this is the form that Harris County uses in order to request service. In this form, you're going to have to put the name of the party, the address for where that party may be found, whether it is their residence or even an address where they're working. People have been served at their employer's address. And then certainly you're going to have to pay for the citation to be prepared by the district clerk's office. In Harris County, it costs $8, I believe, in order for the citation to be prepared, in addition to the amount that you'll have to pay, the fees that you'll have to pay to have the documents actually personally served by the constable's office. And if you don't want to have the documents personally served by the constable's office, you also have the option to have them mailed by certified mail return receipt request through the district clerk's office. But those are the options that you have. And so you'll have to check citation for personal service, and then you'll have to check whether or not you're doing the citation by the constable, or if you're doing the mail service, or what you also could certainly do is hire a process server. There are many people out there that actually provide those services. They, process service, they serve individuals in these lawsuits. And so that we can hire someone. Sometimes they cost about the same thing as hiring or paying for the constable's office. And it's really a personal preference as to which route you decide to go. Either way, service is going to have to be done if there is no waiver of service executed by the respondent. And this is for a case where you have an address in order to find the respondent. And so what happens in those cases where you don't know where the respondent is? Or in those cases where the respondent is evading service, which happens a lot, so in those cases, we'll look at those in just a second. And so each respondent must be served with the initial court papers. And so you filed your original petition for divorce, you completed it, you filed it with the court or with the clerk's office. And so then you'll have to get those documents. Those are your initial documents, in addition to your citation that you haven't prepared by the district clerk's office. Those are the documents that are actually going to be hand delivered, personally delivered to the respondent by the constable's office or your process server. Unless the citation or court order otherwise directs, the citation must be served by either delivering to the defendant in person a copy of the citation showing the delivery date and of the petition, or mailing to the defendant by registered mail, return receipt request, a copy of the citation and of the petition. That's what we just went over. So you'll have to arrange for the constable or sheriff or a private process server to serve your initial court papers. In Harris County, if the party is also living in Harris County, you can just have the constable's office serve those documents, or you can have a personal process server serve those documents. But what happens if you have a party who's living outside of Harris County? In a situation like that, you'll be responsible for reaching out to, if you're going through the constable's office or the sheriff's office, you'll be responsible for reaching out to whichever county police department is servicing the area where that respondent is residing. So for instance, if the respondent is residing in Fort Bend County, you're going to have to contact the Fort Bend County Sheriff's or Constable's office in order to arrange for that service to be executed by that department. And then you'll have to pay whatever fees they assess for that service to be done. And so the clerk's office doesn't assess those fees, because that would be dependent upon that police department. Or the process server, a lot of times those process servers will serve in various counties. That's another good reason or benefit for using a private process server, because they will sometimes go to various different counties in order to get your service executed. So no person who is a party to or interested in the outcome of a suit may serve any process in that suit. And so a lot of the concept of service may be a little confusing to pro se parties, because in your mind, you're probably thinking, well, I could just deliver these documents to the respondent. I'll see him, next weekend. So let me just go ahead and take him these papers so that we can get the case started. And so for purposes of these court proceedings, that would not be considered valid service unless the respondent is filing or executing a valid waiver of service. It certainly can be sufficient for a situation like that. But if we're talking about personal service, if you're a party that's interested in the case, which means that you're either a petitioner or respondent or an intervener, which is another individual that's entered into the case, then you will not be able to serve the initial court papers. This is just for the initial court papers. So you won't be able to serve those papers to the responding party. You need to actually hire a private process server, have the constable's office in the appropriate county do it, or have the clerk's office mail it by certified mail return receipt request. And one thing I want to say about getting the service done by certified mail return receipt requests is the responding party is going to be required to sign those green cards. So when you mail those documents out, when you're mailing any document out by certified mail return receipt request, the other party who's receiving the mail will have to sign those there's a green card they'll have to sign. And so that card will go back to the district clerk's office, and that card will be filed by the district clerk's office as your return of service. So if the respondent is not the person who actually signed the green card, or if it was not signed at all, then that would not be valid. That would not be a valid form of service. And so if you're going to be opting for service by certified mail return receipt request from the district clerk's office, then you probably want to make sure that it's being sent to a good address for the respondent, and that the respondent is actually going to be the person that's signing off on that mail being received. Because that's what was going to be actually filed with the court in order to show proof that the document was actually sent to and received by the respondent. So in a case where the respondent either cannot be found or is evading service, you may have to do what's called alternative service. And there's very different forms of alternative service. You can have alternative service by posting, service citation by publication, or any other form that the court deems will be a sufficient form of service. So if a respondent cannot be found, you'll have to ask the judge first for permission to serve the respondent another way if the constable, sheriff, or private process server has already attempted to serve the respondent in person or by registered or certified mail without success, and you can confirm that the respondent lives, works, or can be found at the location where service was attempted. So what does that mean? That means is you'll have to at least attempt to have that person served before you request, submit your request for the alternative service. And so in this case, you'll have to, sometimes you have to waste a little money, and it takes a little time because you'll have to at least attempt service at the address, the last known address for the respondent before the court, a lot of times before the court will approve this. And you'll have to get an order for substitute service granted by the court. And so first you'll have to file what's called a motion for substitute service. Usually along with that motion for substitute service, you need to also submit an affidavit in support of that motion. When you attempt service by personal service, by either constable's office or a process server, or even, certified mail, a return of service will be provided. It will be sworn to by whichever individual was attempting the service. And if it was not executed successfully, they will include all of that information in their sworn statement. And included in that information is going to be, the date and time it was attempted. A lot of times they'll include a little bit of detail, whether or not there were vehicles outside, or, whether or not there was an individual who answered the door and maybe slammed the door in their face when they realized it was a process server or the constable's office there to serve documents. But they will include that information. And that sworn statement is something that you want to attach to your motion for substitute service. In addition, you may even want to include a statement from yourself as well that's attesting to whatever address you're using in your motion being a valid or a good address to communicate or to reach or find the respondent. So you want to make sure that you're including those with your request for permission to serve, because if you don't submit a request by form of motion for substitute service, then you will not be able to serve the respondent by any other means other than the personal service or certified mail return receipt request, or by submitting a waiver of service. So upon motion supported by a statement sworn to before a notary or made under penalty of perjury, listing any location where the defendant can probably be found, and stating specifically the facts showing that service has been attempted in person or mailing at the location named in the statement, but has not been successful, the court may authorize service by either leaving a copy of the citation and the petition with another person older than 16 years of age at the location specified in your statement. And so that's another thing that's important about this. If you're getting service by alternative service granted, if it's done by the constable's office or even the process server, they need to make sure that when it is executed, when they're handing those documents off to any other individual that's residing at that particular location or address, that individual is at least 16 years of age. And so it may even be important to ask for ID, if, you know, the process server, just to make sure that that's not going to be an issue that the parties or the petitioner is going to have to face later on. In any other manner, including, and so this is something else that can be granted by the court. So they can grant permission for alternative service by electronic means like social media, email, or any other technology that the statement or other evidence will show can reasonably be effective in giving the defendant or respondent notice of your suit. And so that's where it may be important for you to submit your own sworn statement attesting to, you know, specific facts as to whether or not the respondent or defendant can be found at whatever location or can be notified, reasonably notified by whatever means you're requesting permission to have service be done. So I did, briefly mention service by posting and service by publication. Service by posting is typically not something that's granted for a case where there are children involved. And service by posting is typically where the petitioner will get permission to have the pleadings and the citation just posted either in the courthouse, and now they have a specific website where those documents can be posted in order to give notice to the responding party. And so the courts typically don't allow service by that particular type of means if there are children involved. If there are children involved, a lot of times the courts will default to service or citation by publication. There's certain things that you need to be aware of if you're asking for service by publication, because there's a lot more fees involved with that. And it certainly takes a lot more time in order for the service to be executed. Service by publication means that you're posting your notice with a copy of your petition and all that, the citation, in the local newspaper. In Harris County, we use the Daily Court Review typically for service by publication or citation by publication. And so if you're doing that, the fees that you have to consider would include the fee that you have to pay for having the citation prepared. We talked about that. It's about $8. The fee for having the service by publication, so you have to pay the district clerk's office for that particular fee as well. In addition to the fee that the newspaper service or newspaper company is going to charge for you posting that information in their newspaper, however many times you have to post it. And so they set their own fees. In addition to that, once your case has been posted, your citation has been posted, the court is also going to appoint what's called an attorney ad litem. That attorney ad litem is going to be appointed in order to at least attempt to locate the responding party or to represent that party's interest in their absence. And so they have to be paid too. So the court doesn't set their fees, they set their own fees. And a lot of times their fees are going to be dependent upon how much, effort they have to put forth. How long are they going to have to be on this case? How many court hearings they have to appear in? How much investigation they have to do in order to even try and find the responding party. And so it's certainly in your best interest, if you're having an attorney ad litem appointed to your case because you're doing service by publication, you need to be working with that person and providing them as much information as possible so they're not utilizing too much time in doing their due diligence so that you can move forward with your case, because you may be looking at upwards of $1,500 for their attorney's fees in order to get that service by publication completed. And so certainly you want to keep those things in mind. If you're having to do alternative service, it's a remedy that's available to you if you cannot find the respondent, or if the respondent is not trying to be found, because that certainly happens a lot. All right, children issues, parental rights. In Texas family law, we have what's called conservators. All right. And so that's a legal term that we use in court that references the parties, a person with the court-ordered custody of a child. And so there's certain different types of conservators in our courts. the presumption in Texas is that, parents should serve as joint managing conservators, which means that they're sharing in the rights and duties and sharing in the possession periods with the children. Texas law says that parents should usually be named as joint managing conservators. A joint conservatorship order means the parents share decision-making about most issues including decisions like, invasive medical procedures, educational decisions, healthcare information, or decisions for the children. And so usually in those joint managing conservatorship agreements or joint managing conservatorship orders, those rights and duties are shared. Sometimes they're shared on a not necessarily 50-50 basis sometimes, but they certainly are shared. In Texas, a Texas Law Help, again, has a lot of information on child custody and conservatorship. This Texas Law Help in general is really just a good resource for pro se parties, even if you're just trying to get information on what it is that you're even, what we're even talking about here. These legal terms that are used in court, the processes that are used in these proceedings. Texas Law Help usually has some pretty good articles that the pro se parties can review in order to get that information. And a lot of times those articles are written in a way that's easily understandable. Sometimes if you're looking at court documents, they're written in legal jargon, and Texas Law Help is really good about avoiding all that. And so sole managing conservatorship is another form of conservatorship. And usually, well, not usually, in sole managing conservatorship, the custodial parent will have the exclusive rights to make most of the decisions concerning the children, if not all of the decisions concerning the children. And so again, those are decisions like invasive medical procedures, psychological and psychiatric treatment for the children, educational decisions for the children, whether, decisions on whether or not the children can be enlisted in the military as a minor or even marry as a minor. Usually in sole managing conservatorships, those rights are exclusive as to the custodial parent or the sole managing conservator. Excuse me. And then we have a possessory conservator. So if one parent is named as either a sole managing conservator or a joint conservator, then another parent will be named, or the other parent, excuse me, is usually named as a possessory conservator, which means that is the party that's going to have possession periods where visitation with the child. A possessory conservator still will have some rights as a parent, but will not have the final say on most of those decisions. And so a lot of times with the possessory conservator, you'll see rights that are kind of worded that, the custodial parent may have the exclusive right to make decisions concerning education after consulting with the possessory conservator. So it may be worded in that regard. And so that's what we have as far as the conservators are concerned. You have your joint managing conservators, your sole managing conservator, and then your possessory conservator. And so with each of those, you have to decide, the court's either going to decide or the parties can come to an agreement as far as the rights and duties for the parents. And again, usually with joint managing conservatorships, the rights and duties are, virtually shared by the parents. And then with sole managing conservators, you have the sole managing conservator who has the exclusive right to make most, if not all, of those decisions. Possession and access. Possession and access, is another term that we use in court. It just basically means visitation or your time that you have with your child, that you're entitled to with your child. A possession order says when each parent, or sometimes a non-parent, has the right to time with a child. And so your possession orders in your divorce case, because those are going to be included in your divorce case, should be very specific. When I say specific, I mean that you need to include the actual time that visitation is going to begin on specific days and the time that the possession is going to end on those specific days. For in reference to a standard possession order is what the courts have deemed, or there's a rebuttable presumption that a standard possession order provides reasonable minimum possession of a child for a parent named as a possessory conservator or a joint managing conservator, and is in the child's best interest. And so the standard possession order is what the courts have determined is, typically in most situations in the children or the child's best interest for the non-custodial parent to have. And so what exactly is included in the standard possession order is what you typically have the first, third, and fifth weekends. Usually it's, beginning at 6 p.m. on Fridays and ending at 6 p.m. on Sundays. During the school year, you'll have Thursday visitation periods from 6 p.m. to 8 p.m. You'll have alternating holidays. Usually the custodial parent will have 30 days in the summertime. They can either give notice by a certain date, typically is April 1st, as far as what days that person would like to have in the summer for their visitation period, or there's a default time period from July 1st through the 31st if that notice isn't given. And so that's usually what, a standard possession order will entail. Now, Texas law has, a separate provision for parents who live 50 miles or less from one another. And so the courts have determined that, those are close distance from each parent and should be in the best interest of those parents or the child to have what's called an expanded standard possession order. It's a slightly different as far as the time that the parent or the non-custodial parent will get with the child. And so for purposes of the expanded standard possession order, usually it starts first, third, and fifth weekends, starting at the time your child is dismissed from school. And so it's not 6 p.m. It's at the time your child is dismissed from school. So that could either be, 3 p.m., 3:30. You'll have to reference the actual school schedule where your child is attending or where your child would be zoned to attend. And so it starts at the time your child is dismissed from school, and then it is over on that following Monday when school is to resume after the weekend is over. And for Thursdays, instead of the 2-hour 6 to 8 visitation period, the non-custodial parent will have an overnight stay during the school year. And so you'll have time from the time that child is released from school up until that Friday morning. And so that's something that, to consider now, since that's something it's standard now for parties who live 50 miles or less from one another. Then we have a modified possession order. Modified possession order is really kind of like a catch-all. Anything that's outside of or different from a standard possession order. A lot of times when parties go to mediation, and that's one thing that's not covered in this presentation because it really is beyond the scope of, this divorce presentation. But a lot of times the courts will require the parties to go to mediation, usually to go to mediation before you move forward with a hearing, whether it's a temporary orders hearing or a final hearing. And through mediation is where I usually see these modified possession orders, because there you have the opportunity to really craft an order that better suits your circumstances. A lot of times, if you're getting the court to rule on these possession schedules, they'll kind of default to what's standard unless there's evidence presented for the court to consider some other schedule that's better suited in whatever particular case you have going on. So modified possession order could, be like a week on, week off schedule. Sometimes I see parents do that if they live close enough and they're able to co-parent in order to do so. Or you may see something else that's just completely custom made. I've seen it many different ways, everything under the sun. So you certainly have the opportunity and the option to do that. Possession orders for children under the age of 3. A lot of times, I'm going to say usually, but a lot of times when there's a child that's under the age of 3, the court will grant what's called a step down or stair step visitation schedule that will start with a more restricted schedule perhaps, and then graduate to something closer to or that is a standard possession order. And so there's certain things that the court is going to want to take into consideration before they're granting something like a possession order, like a stair step possession order for kids that are under the age of 3. Some of those things that the court's going to consider is, you know, the caregiving that's provided to the child, or who's actually providing that caregiving to the child, the effect that separation will have on either, you know, have the effect that separation from either parent will have on the child. And where I've seen that really come into play sometimes, come into play is where perhaps you have a small infant that's being breastfed, perhaps. You know, we have a small infant that's being breastfed. The courts, you know, sometimes may find that it's not in that child's best interest to have a standard possession order where the non-custodial parent, who's not also the breastfeeding parent, will, you know, have full weekends. All right. And so sometimes the courts will consider things like that. Sometimes not, because, you know, we could always, you know, pump. All right, and so the courts may also consider the availability and the willingness of the parties to be caregivers as well. And so if we have a party who is either incapable or unwilling to care for a small child, then that may be a reason for the court to consider a different type of schedule for a child that's that young. The courts may also consider the impact of others who will be present during possession period. So if there is an allegation that there's somebody living in, you know, the non-custodial parent's household that's, you know, inappropriate to be, you know, be around the children or to be in the presence of the children, that may also be something that's considered by the courts in awarding a schedule like that. Or if there's siblings in either household, the courts certainly consider, you know, siblings in either households, because they want to make sure that those children are also getting time with their siblings. And so what about supervised visits? You know, sometimes, a lot of times you have parties request supervised visits. Sometimes it's warranted and sometimes not so much. You know, supervised visits is something that the courts will grant really only after evidence is presented that warrants such a schedule. In Harris County, supervised visits are typically done through Harris County Domestic Relations Office if it's done by a third party, or sometimes I've actually seen where you have a family member or the other, you know, party, the opposing party, supervised possession periods. Is really up to the preference of the parties themselves, if they're agreeing to it, or to the court if it's being ordered. In cases where I've seen supervised possession orders being granted, or where the non-custodial party may have a history of drug use, you know, may have a history of having criminal cases that, you know, are relevant. You know, maybe there's a domestic violence type cases, or, you know, out there. Domestic violence is certainly a reason the court would want to consider a supervised possession order. Like I said, drug use or alcohol abuse as well. And so you would have to present evidence to the court in order for the court to grant something to, you know, to this effect, because otherwise, you know, the courts may want to default to those standard possession orders like we mentioned before. Child support. Another one of the kid issues, more, you know, important kid issues, is going to be child support. Because in Texas, you know, we assess child support. It's, you know, statute based in our state. Unless it's agreed to by the parties, you don't have to go by the guidelines if you come to an agreement. The court may order either or both parties to support a child in a manner specified by the order. So if one party or one parent is the custodial parent, which means that that's the parent who has the primary right to determine the residence of the child, then the other parent will usually be required to pay child support. Again, that amount can be agreed to by the parties. Sometimes the parties agree that there's going to be no child support at all. And so if you're filling out your court documents and you're asking the court to approve no child support, you need to actually write that in, you know, zero amount for no child support, right? And so in Texas, effective September 1st, 2019, the guidelines for support of the child apply to situations in which the obligor's monthly net resources are not greater than $9,200. So we're not like other states, you know, like California, perhaps, where you can get however much in child support, depending upon how much that non-custodial parent is making. The sky's the limit. We don't have that here in Texas. We have limitations. It increases, you know, periodically At one point in the past, it was, 7,500. Now it's up to 9,200. And what that means is that when you're calculating your child support, even if the respondent is making net resources in the amount of 10,000 or more, you can only look at up to $9,200. And so when you're calculating it, the child support, for instance, for a case where there's only one child and you have child support that's above and beyond that 9,200, you would be calculating 9,200 times that 20%, and then you'll get your child support number. There may be some other factors involved in there, like, medical support, but, for lack of, other information or the details to be added to that, that's really how it would be calculated in Texas. And so if you're making that, the responding party is making 15,000, net resources per month, you don't get to calculate child support based on that amount. Usually you don't get to calculate child support based on that amount. You have to limit it. It is capped. And when I say net resources, I'm not just talking about, how much he's making monthly from his job, or I say his for lack of a better terms, it could be his or her, because we have moms and dads who pay child support. And so net resources includes whatever resources are included, is not just the wages, it can be any other additional funds. They could be getting funds from somewhere else, perhaps on a regular basis, that could be included in those net resources. As I've even seen, net resources to include like Social Security or whatever veterans benefits sometimes, that can be calculated in order to get child support on a monthly basis. So that's how the calculation is done in Texas. In Texas now, we also have a separate calculation schedule for those parents or non-custodial parents who are low income. And so if you're low income, if the obligor, if his or her monthly net resources are less than 1,000, which is what's considered low income for these purposes, the court shall presumptively apply the following schedule in rendering the child support order. And so you saw in the regular schedule, child support for one child is 20%, for two children is 25%, 3, 30, 4, 35, 5 children is 40%. For low income, those percentages are reduced some, right? And so for one child, you're calculating your monthly net resources times 15% for one child, 20% for two, 25% for 3, 30% for 4, and 35% for 5 children. And so that's how our child support is calculated here in Texas. For guideline child support, again, if the parties agree to it, they don't have to have guideline child support. You can agree to whatever number you want to agree to. But if you're letting the court decide, the court's going to be calculating that child support based on these figures. All right, and so your property issues. In Texas, we have our assets and debts. As far as the assets are concerned, we have our community property, and then we have our separate property. When you're filling out usually it comes into play when you're filling out your final decree. And so when you're filling out your final decree, you need to make sure that you're listing all of the community property and listing all of the separate property. Sometimes it's confused by pro se parties of what property they should be listing. Sometimes they get it confused where they think, well, we haven't been together, for instance, in a case where, the parties have been separated for a little while, and they have acquired this property, whether it's bank accounts and vehicles or things of that nature. In Texas, we don't have legal separation. All right. So that's one thing that needs to be understood. Texas, we're either married or we're not. Right. And so if we're married, our community property is all property that's acquired during the course of your marriage, or the property that you still have at the time that you're filing your divorce, except for certain items of property. Right. And so separate property would be considered property that you owned before you were married. In Texas, typically it's based on when that property was acquired, with the exception of gifts or inheritances, or money received for personal injuries that occurred during the marriage, unless those personal injury fees that are received are for lost wages or medical expenses. And so separate property, if the property is acquired during the course of your marriage, whether it's, while the parties were actually residing together as husband and wife, or up until the point that your case is actually, finalized in the divorce, then that's that separate property, or that property that's acquired in that period would be community property, unless it's given to you as a gift or you inherited it, by a family member. In that case, it will be considered your separate property. All right. And so that certainly is important to remember when you're trying to finalize your case, because like I said, in Texas, if you're still married and your case has not been finalized, your divorce has not been finalized, you're still accumulating community property. And so I've seen pro se cases where the parties have told me, well, we don't have any property together. We haven't been together in X amount of years. And so you don't find out until after you question a little more, like you don't have a vehicle, you don't have any bank accounts, you don't have a 401k. And they start thinking like, well, yeah, I have all those things, but they're in my name. You don't have a residence, perhaps, well, yeah, it's only in my name. But in Texas, if it's acquired during the course of your marriage, it really doesn't matter whose name it's in. All right. And so that's the reality of it here. It's really dependent upon when it was acquired or how it was acquired, whether it's a gift or inheritance or a personal injury outside of lost wages or medical expenses, or in addition to stock dividends or capital gains that are acquired from separate property investments. All right. And so if you look at your original petition that we looked at before, I believe the original petitions on Texas law help actually have definitions of community property and separate property, so that the parties are aware and kind of, get it in their thought process, like these are things that need to be considered, even if it is in my name only. If it was purchased during the course of my marriage by either myself or my spouse, then we're going to have to list it as separate or community property, and we're going to have to award it to either the petitioner or the respondent, one party or the other. And so you have your debts. In Texas, we have our community debts and we have our separate debts. And a lot of times when you're finalizing your case, the parties may like to cut off the division of debt from the moment that the parties were separated. And so that's something that you can include in your final decree. Community debt, again, like community property, is that debt that you acquired during the course of your marriage. And then separate debt is that debt that's acquired before you got married. And so the law says that separate property or separate debt cannot be divided. And so that's why you want to classify it either as separate or community property. And so that way the court will know how to treat that particular item of property. And what I'll say again about the property or assets and debts when you're completing your final decree, and we'll talk about that a little bit further on in the presentation, but when you're completing your final decree, you want to list all the property that the parties have together. And if there's a specific item of property, if you're using those Texas law help.org forms, if there's a specific item of property that doesn't conform to your case, for instance, like if you don't have any real estate, then you want to mark NA like not applicable, instead of just leaving that information blank, because again, the court wants to see that you've actually addressed each of those sections when you're filling out those documents. And those are one of the issues that we see quite often when we're reviewing our orders through our pro se litigant program. So inventory and appraisement, which is an inventory and appraisement is typically just a list of all real and personal property, as well as debts and liability, claimed by each spouse. This list will include your separate property, your community property, your debts that you and your spouse have acquired. And this list is necessary. It really is necessary to help the judge make a just and right division. So when you have an uncontested case, or even a default case, because I see it a lot of the courts require these appraisements or inventory and appraisements for default cases as well. This helps the court to determine whether the property that's actually there within the estate, the community estate for the parties, or the separate estate for the parties. And so you need to make sure that you're submitting or filing your inventory if you have a contested case or if you have a default case. And a default case is where you have the parties been served, they have not filed an answer, and so you're moving forward by default. And so your inventory and appraisement will need to be sworn. A lot of times, sometimes people want to file these documents without having them notarized. But you want to have them sworn before you file them. That means that you're having it notarized, or you're signing it in the presence of a notary, because you're attesting to this being all the property that we have between the two of us, or all the property that's, either separate or community property that should be considered and divided by the court. All right. And so that usually is why these courts want to make sure that you're filing these in those uncontested or default cases. And unfortunately, Texas Law Help doesn't have an inventory and appraisement form. Hopefully one day in the future they will, but they don't. But you can get a form from the law library. The Harris County Law Library has some good forms that they will provide. Or if you have your documents, your final documents and your court orders reviewed by the Harris County Domestic Relations Office represented litigant pro se litigant program, then we'll actually provide, if you don't have one, we can provide an inventory and appraisement for you to complete and fill out. So there's ways for you to get those forms. It's not necessarily something that you want to try and draft from scratch if you can avoid that, because there's forms out there for you. You don't have to reinvent the wheel. All right, so answering the divorce. And now we're going to talk about what the respondent needs to do after this case has been filed by the petitioner and the respondent has been served. Then what? What are you supposed to do? Well, you have a deadline to make, all right, as a responding party, if you do not want a default judgment to be granted in your absence. And so usually when the original or the initial court papers are filed, not usually, when they're filed, we'll just say it like that, they are filed with your citation, the citation that's prepared by the district clerk's office. And within that citation will be a notice to the respondent. And the notice will say, the citation, you have been sued, all right? You may employ an attorney. If you or your attorney do not file a written answer with the clerk who issued the citation, and it's very specific, by 10 a.m. on the Monday next following the expiration of 20 days after you were served this citation and petition, a default judgment may be taken against you. And so I know just reading it out loud may sound a little cumbersome, a little confusing. Like, when am I even supposed to get this filed with the court so that I'm not getting a default judgment granted against me? But the way that you want to calculate that time is from the day that you're served. You want to calculate or count, starting from the next day, 20 days. And then after that 20 days has been counted or calculated, that next Monday, that very next Monday, after you calculate those 20 days on your calendar, or count those 20 days on your calendar, will be your deadline. So 10 a.m. on that Monday will be your deadline. So this is a very specific notice that is included in your citation. And, those citations, when you receive them as a respondent, I can't stress this enough. It's so important for you to actually read it and respond. When you're responding, we'll get to your general denial, your answer. It's usually like a one-page document that you have to file in order for you to protect your interests, but it's so important because what you don't want is for a divorce case or any kind of civil or action that's filed against you to be granted or decided without you even being present. And so you're putting your answer on file to put the court on notice that, one, maybe you're in denial, you're denying whatever the allegations are in that original petition that was filed. And then two, you want to be given notice of any proceedings that take place in this case. And so you don't want a final trial on the merits to take place without you receiving notice. And so by filing your answer, you're making sure that you are protecting yourself in that regard. So in addition to filing a written answer with the clerk, you may be required to make some initial disclosures to the other parties. And these initial disclosures generally must be made no later than 30 days after you file your answer. And so usually in these contested cases, that's the law now, is that after you file your answer, you have a certain amount of time to submit those initial disclosures, and you can get that information from Texas Rules of Civil Procedure, Section 99, okay? Now, your original answer or general denial. What is an answer? All right, it's a written answer. An answer is a legal form filed with the court by the respondent in a court case. And so filing an answer with the court protects the respondent's rights to have a say in the case. And so remember what I said, like if you don't file your answer and you've been properly served, after you've been properly served now, if you do not file your answer within that timeline, you very well may be looking at a default judgment. It's not always the case. It just depends on whether or not the petitioner actually goes into court to finalize their case after that timeline has passed. And so if they're real quick on it and they've been on their case and we're going to talk about another timeline, because in Texas, we have another timeline that's really important before you can finalize your divorce case. And so if your timeline for your response has passed in either a divorce case or any other civil matter, then you could be risking a default judgment being granted against you. And after a default judgment is granted against you, you only have about 30 days to file for a motion for new trial if you have good cause to do so. And so in an answer or a general denial, the respondent is not in a suit for dissolution of marriage or a divorce suit. That person is not required to answer an oath or on oath or affirmation. So what that means is that it doesn't have to be sworn. If you're just doing a general answer or an original answer or a general denial, it doesn't have to be sworn. However, if you're including your own, what we call affirmative defenses, if you're including your own defenses that you want the court to consider, then you would need to have that sworn. There. All right, and so in a divorce case, the petition is not taken as confessed for want of an answer. And so what that means is that even if you fail to file your answer, the case that the petitioner has filed is not automatically granted without the necessity of anything being provided to the court. And so usually what the petitioner will have to do is either present an affidavit. Well, most courts now require you to have a hearing and just do what we call a prove up, which is just stating your evidence or your testimony before the court. It usually only takes about 5 minutes if it's a default case, in order for the court to finalize your case. And for purposes of a default prove up, really that party is just stating, facts of the case. Like I married, the other party, whatever that party's name is, on such and such date. We have, these many children, the children of this age. I'm requesting, either joint managing conservatorship or standard possession order, and however much in child support for the children. The party I'm asking for a divorce based on insupportable differences or no grounds or whatever the case may be. And so you're stating those facts in your testimony when you're giving that testimony in your final hearing or your default prove up, whatever the case may be. And so even if the respondent fails to file an answer, the petitioner must deduce proof to support the material allegations in the petition. So that's what I'm just discussing, or just discussed here. The petitioner still going to have to appear before the court in a default case, to present the evidence in order to finalize that case, present evidence to show that the court has jurisdiction to sign off on this divorce, all right, or to grant child support and, order these things that you're asking for concerning the children or even the property that you're asking the court to divide. Just a second. All right, so counter petition. A counter petition for a divorce tells the court what orders you actually want the judge to make in your divorce. And so usually in a divorce case, most times I see this when there's a difference as to what the parties want when it's concerning the children. So you may have one party that files an original petition asking for, joint managing conservatorship and maybe a standard possession order for the other party. Now, if the other party, is served with those documents and determines like, hey, I want to be the party who has the primary right to determine residence. And I don't think the other parent is really a capable parent. And so I'm asking for sole managing conservatorship. And so instead of just filing your original answer or your general denial, you may also want to file a counter petition that is requesting to the court, or putting your request before the court what you're actually wanting to be ordered in your case. All right. And so you're not just basing your case on whatever pleadings were filed by the petitioner, you're filing your own action. In that case, you will be named a counter petitioner and the other party will be named the counter respondent. And so if your divorce is contested, you may want to file an answer and a counter petition for a divorce. Sometimes these pleadings can be filed in separate documents or they can be merged into one document. I've seen that happen as well. It's up to the party's preference. And so Texas Law Help actually does have now, I think this may even be something that's fairly new because I don't think they had this before, but they do have now counter petitions that can be completed by the parties for them to file in their cases. And so there are forms available. If you look here, this is, respondent's original counter petition for divorce. This is an example of one that you will find on Texas Law Help. And again, you just need to make sure that you fill in the blanks for the information that is specific to your case. What to expect in court. I remember before we were talking about some timelines or deadlines that we need to be cognizant of. One being that the response deadline, you need to make sure that you're filing your response before 10 a.m. on that Monday following the expiration of the 20 days that you're counting on your calendar. Also, what's important in Texas, you need to be aware is that the Texas courts do not allow divorces to be finalized before the 60th day after the date that your suit was filed. Outside of certain circumstances, right? And so for typical general circumstances, usually the parties will have to wait at least 60 days before they can finalize their case. And so even if one party, the responding party, hasn't filed an answer by that timeline, that 20-day, Monday after the 20 days, they still may have some additional time because the court will not allow the case to be finalized until after the 60 days is expired as well. And that's, in my opinion, that's really for the courts to determine whether or not there's a chance of reconciliation between those parties. And then there's the waiting period for 60 days. There are some caveats to that. And so in a case where there's an annulment, if the party is trying to get an annulment, there's no waiting period for that. Or if the court has determined that there has been a history of family violence, or if there's an active protective order or one of those emergency magistrate orders, then the court may waive that 60-day time period. But you'll have to, plead for the waiver of that 60-day time period if you're trying to hurry up and get divorced immediately. All right, so response or default. Again, remember, when you're getting your petition served on you as a respondent, you want to make sure that you're filing a response within that timeline so that you do not suffer the risk having a default judgment being granted against you. So by timely filing your answer after being served with a divorce petition, you are protecting your rights as a party, and you will be entitled to notice of any proceedings that take place in your case. So the petitioner will not be able to finish your case unless the respondent has agreed to and signed a final order, or the petitioner has given the respondent legal notice of a contested hearing. All right, and so for a default judgment, if you've been given proper notice as a responding party and you fail to appear at your hearing, then the court will grant a default judgment against you. So you want to make sure that you're appearing at your hearing. Or if there's a case where the responding party has not filed a response and the petitioner goes in to finalize their case, one thing they want to make sure that they do is have the return of service on file at least 10 days prior to the date that they're trying to finalize their case to show proof that that service has been properly executed. All right, so courtroom decorum. Once you get into that courtroom, even Zoom hearings. So there's certain things that you want to make sure that you are cognizant of so that you are not embarrassed by these judges and that you are putting forth your best, presenting yourself in the best way possible, right? And so you want to make sure you dress nice. I've actually seen people appear, especially since the courts are now allowing these appearances via Zoom, in jeans or shorts or, flip-flops. Unfortunately, I've even seen a judge had to admonish an attorney, to go and put a suit jacket on. You're not dressed properly, a little too casual for court. And so you want to make sure that you're, presenting yourself in a professional manner. You want to address the judge properly. And so you don't want to say, hey, you, or call the judge by first name basis. You want to, address the judge as your honor, or perhaps judge, or sir, or ma'am. You want to be polite. You want to speak clear and concisely. You want to speak loud enough for the judge and the court reporter to hear you. Because especially if you're in person. So if you're in person, a lot of times the court is set up where the judge is kind of, a little bit sitting above everybody else, for lack of a better term, and looking down on everyone else. And then the court reporter will have to record everything that's being said. And so you want to make sure that you're speaking loud enough for the court reporter to hear, you're not talking over anyone else, and you're speaking slowly enough for those statements to be recorded. You want to make sure that you're not interrupting anyone, especially the judge, because the last thing you want is for the judge, to be on the judge's bad side. And that's a good way, an easy way to be on the judge's bad side. And you want to know, understand that this is the person that's deciding your case. And so you don't want to be on that person's bad side. You don't want to be eating or drinking or chewing gum while you're in court. And this even includes virtual court hearings, because even though you're via Zoom or whatever the case may be, it's still a court proceeding. You still have to treat it as such. And so you shouldn't be eating or, drinking or using your cell phone and things like that during those court proceedings. It's even more so important if you're doing your proceeding via Zoom. And also what I wanted to make sure that I made mention of, because I see this a lot too, is if you're appearing via Zoom, make sure that you're in a safe, stable environment. You're not driving anywhere. You're not walking around, trying to talk to the court at the same time while you're on Zoom. And you want to make sure you're in a location where you have good Wi-Fi, because you don't want to be cutting in and out during your court hearing. And then finalizing your case. So finalizing your divorce case. So there's different ways that you could do it. If you have a divorce that's by agreement, you have a valid waiver of service on file, the other party has signed off on your court order, then a lot of these courts will allow you to also file a sworn prove-up affidavit. Now, the prove-up affidavit is just a sworn statement that is really your testimony, the same testimony that we went over that you would be presenting to the court in person. You would be writing out in a sworn statement that you have notarized, and you'll file it with the court along with your final order and your closing documents. And so that way you can have your case determined by submission. It's a lot of times you just notify the court that you filed those documents, and the court will go in and either sign off on everything, and if everything looks good, or decline to sign off on everything. And usually they will write a note in their court docket to give you some information as to why they were not able to sign off on your order. So you may also complete your case or finalize your case in person or by remote appearance. Usually these courts right now are, for the most part, still doing remote hearings, especially if we're doing divorce cases or default or uncontested cases. You may be able to get an in-person case if you have a final trial for a contested divorce. But again, that's where your testimony comes into play. Our office, because we have the self-represented litigant program where we review court orders and closing documents, we also will review your prove-up affidavits or provide a blank prove-up affidavit or testimony that we get from Texas Law Help, because you can still get all these documents that we provide, we get from Texas Law Help. We can submit those or provide those documents to you as well for you to finalize your case. If you're doing the in-person or remote appearance, you just need to read from your sample testimony. That's not something that you would need to get filed, but it absolutely is helpful, because that way you're not stumbling over your words when you're trying to finalize your case in your final hearing. If it's a divorce contested trial, that's something completely, that's a whole different ball game, because then you're looking at, you know, an adversary hearing, you have evidentiary rules that you have to comply with. And so that is certainly beyond the scope of this presentation. But then you have your final order. Your case is not done. And I can't stress this enough, because your case is not done until the judge has actually signed off or signed your final order or your final decree for divorce. It doesn't matter if the other party has signed it and you've signed it and y'all filed it with the court. It's not over until the judge signs, all right? And I've actually seen cases where the parties thought, okay, we're divorced, you know what, we're divorced, we already signed off on those documents, we filed them with the court years ago, and they're at actually I've seen a case this like this before, where they were in the process of trying to get remarried, and then realize, well, I'm not actually divorced yet because the judge never signed off on my order. All right. And so you want to make sure that your order has been signed. So don't just file it and leave it and never look back. File it, check in with the court, make sure it's been signed. And at that point, your divorce case will be finalized. All right. And so then you can move on with your life and do whatever else you have to do. All right. So we got some resources that are absolutely helpful. I used a lot of texaslawhelp.org during my presentation today, and I referenced it a lot in my presentation today because I cannot stress how wonderful. I really think that I can't speak highly enough about it because it has a lot of information for pro se parties, and it's written in such a way that it's just not confusing. You know, it's very helpful information. You have forms that you can use, and so you don't have to worry about, you know, trying to draft a form yourself, or God forbid, hiring one of these services or paralegals out here that try and draft these legal documents where they very well should not be doing that. So certainly use Texas Law Help if you can. We also have in my office, a shameless plug here, but my office, the Harris County Domestic Relations Office, has our pro se litigants program, where we review your court orders, your final divorce decrees and your closing documents, because there's certain closing documents that each case will need in order to finalize your case. And then we'll provide whatever additional documents like your inventory or your sample testimony, and, you know, hopefully answer whatever questions you may have in order to get you to that point where you can finalize your case. And I can't speak highly enough about the program because it prevents you from having to go back and forth to the court. It's very frustrating to have to do that. This is a process that's frustrating enough. The last thing you want to have to do is have to keep going back and forth to the court trying to get your case done, and because you have issues going on with your court order. And so some of the courts have standing orders in place where they are requiring the parties to go through our office before they finalize their cases. Some of the courts don't have it. Either way, it's a very useful resource for pro se parties. And then you have the Office of Attorney General if you have those child support cases, or even cases where we have children born before your date of your marriage. In that case, it may be beneficial for you to contact the Office of the Attorney General to have paternity established for those children. We also have legal lines. Legal lines is a very good resource as well. If you just have a question that you want to call and ask concerning a case or your case in general, you can give them a call and set up a call, and they usually can answer those questions for you. If you're trying to get an attorney to represent you, there's certain resources out there for pro se parties for pro bono services. So those are going to be free services. You have Houston Volunteer Lawyers, a wonderful organization. I used to work for them before. They provide a wealth of services for pro se parties. So that's the contact information for Houston Volunteer Lawyers. There's also Lone Star Legal Aid. They also provide pro bono legal services, in addition to aid to victims of domestic violence. And so if you've been a victim of domestic violence, you can go through AVDA to get some legal representation. And that's just some of the resources that are available out there for you. And if you're trying to hire an attorney, we don't recommend specific attorneys through our office, but we do provide information for Houston Lawyer Referral Service, where you can contact that service and get information on various attorneys in the Houston area that represent parties in the legal field that you're looking for. Not just family law, they have attorneys that represent parties in different types of areas. So that's, you know, the presentation. If anybody has any questions, now would be the time to ask.
Man, that was a lot.
I know.
At first, I was sitting here writing it down. I'm like, okay, I'm missing stuff. Let me just go ahead and just listen because I can't keep up with writing.
I know, and I hope I wasn't
same
speaking
time,
too
so.
fast.
It was just a lot. I have a couple of questions too, but I want to get to the question that just popped up here in the chat. Is common law marriage still a thing? If so, at what point would community property and debt take effect? Also, are individual school loans for multiple degrees considered community debt?
Are we talking about school loans for the parties?
I'm assuming so, yes.
A lot of times those school loans, you know, they can be classified as community debt, but a lot of times they look at those as separate property because those are, you know, loans that you're getting for your own benefit. And then what was the other question?
About community, or common law marriage.
Oh, common law marriage. Yeah, common law marriage. We do look at common law marriage in Texas. Texas does recognize those common law marriages, but you will need to plead for it within a certain amount of time. You don't want to let too much time, more than 2 years, go by before you actually file a divorce suit if you're stating that your marriage was via common law. And so if you've already separated, you know, after a certain period of time, then the courts determine that, you know, in the common law marriage, so that if you're in a common law relationship, you want to make sure if you're separated that you're filing your divorce case in a timely fashion. But yes, Texas does recognize it.
At what point does it become recognized as common law?
Oh, at the point that the parties actually present themselves as husband and wife, okay. Or put themselves out as husband and wife. So a lot of times these common law marriages is really fact-based. And so you may have to put on some evidence as to when that marital relationship began.
Because he followed up with a question, common law marriage is living together for 6 months. Is that correct? It's not
that's a part of it. That's a part of it, because
there is more.
Everybody that you live with for 6 months is not going to be your husband or wife, right? That's not going to be your spouse. So in addition to living together as husband and wife for 6 months, you need to be putting yourself out there as husband and wife. You know, whether you're telling family members that you're husband and wife, you're, you know, putting this person on your insurance as your spouse, you know, you're purchasing property as husband and wife, whatever the case may be, you need to be able to present some sort of evidence that you are or have been presenting yourself as husband and wife, in addition to living together for that period of time. So it's just not that.
One of our previous attorneys would say that, you know, mail, Christmas cards, all that types of stuff would have to be presented as Mr. and Mrs.
That's why I say it's very it's fact-based, you know, so you will have to put on some evidence. And so you may even have, you know, things like pictures being presented in court, letters, you know, family members coming in or friends coming in to testify like, well, yeah, I thought they were married all this time, that they've been calling each other husband and wife for years now. And so that's the evidence that you can put on. You certainly will need it if the other party is contesting that there was a marital relationship. And a lot of times that becomes an issue when we have property that needs to be divided.
Ms. Myra,
if the person passed, one of the persons passed, how long do you have to file a divorce within that time frame, and you're filing for insurance and filing probate, you know, fighting for probate and all that stuff? How long, if you didn't file for common law, but that person, I guess your spouse then passed, how long after they passed would you have to file for a divorce?
Would you have to file for divorce?
Okay. I believe the time frame is 2 years. Actually, I believe it's 2 years. Even 2 years after that person has passed, or 2 years after the parties have separated, even for you to file that divorce. And that's why I say it's time specific, and you need to make sure you're doing that divorce and filing that divorce case in a timely fashion, right? And so you can't just let too much time go after a death or after you separate before you file your divorce. So if you're common law, you know it, you better go ahead and get that done.
And that was a question where there's a young lady that had been living with a young man for a long time, but he had passed, and she had been trying to fight the family and all this stuff, but she had never filed for divorce.
Oh.
Yeah, that was it. Thank you.
Yeah, and I guess she was never told to do so. You know, sometimes people just think that, okay, well, we lived together for that period of time and we said we were husband and wife and now we're separated, but there should still be a common law marriage established here, right? No, you know, there's certain things that you need to do.
Sadly, when he passed, she was not able to fight probate or any of the other stuff as a wife. So that was the biggest concern. And she actually lost. And that's why she was coming to she came to our classes when we were actually doing them in person. And a lot of the attorneys attempted to help her. But we want to make sure to remind everyone, you have a certain specific time.
You have a specific time frame. Yes. Yes, you can't just sit on that, you know, and that's with anything with these legal actions, right? You don't want to just sit on these.
My question was up, and I think I put it in the chat about the cap, the 90, was it $9,200 or the $9,600 or the $9,500? Is that the annual, the net income, or the annual monthly income or annual income?
Oh, that's a good question. Thank you. Because if I didn't say it before, it's monthly. That's monthly net resources, not just what wages you're getting in. And so that cap is what you're bringing in monthly after taxes and all that.
So 9,500,
9,200.
That's 9,200 is the cap
per
that
month
they could receive in their assets, or the cap that the child can receive.
No. Let's make sure that that's clear.
Can we go back to that slide so we can make sure
that's the number that you can use to calculate your child support, not the number that you're going to receive. That will be paid for child support. So when we're calculating child support, we do it based on your net monthly resources.
Gotcha.
And you know, in Texas, if you make anything over $9,200 per month in net resources, then Texas will cap the calculation that they use, the number that they use to calculate the child support. They will cap it, excuse me, at 9,200. And so where you're looking at how many children there are in any given case, if there's one child, there's 20%. And if you have $15,000 net resources, then in order to calculate child support for that case, then you're calculating 20% times the cap, that highest amount, which is 9,200 in net resources. And that's how you get the child support number that's actually going to be paid by the non-custodial.
Gotcha. So for some of those folks I don't even know that I should say this. So for some of those folks that are disputing child support, when you've got somebody that's threatening to take you to court, thinking that they're going to get more in child support versus what they can actually receive. If you're receiving more than 20% of $9,200 already, you might want to keep your mouth closed.
You might want to keep your mouth shut.
Okay.
And it's even goes for people who, because sometimes, I mean, I always advocate for go ahead and get your child support order, but sometimes people pay, you know, outside of child support without getting an order in place. But you want to make sure that if you're getting more than that, you want to be quiet, because this is not California. You will not get the sky is the limit when it comes to child support. You don't get those cases where we get thousands upon 5-figure, you know, monthly child support figures. You don't get that here. Oh no.
Yeah. Okay. Wow. Okay. There was so much other stuff in here, and I knew I should have kept writing as I was going along here to ask these questions. Okay. So real quick, just a recap, because this was a lot of stuff.
I know.
Point one to finish, the first thing you need to do is
get your petition filed. And so you're going to go to either Texas Law Help, or you can go to library and draft your own petition, but you got to get your petition filed, your original petition for divorce, before you do anything. And then well, first you need to figure out where you're filing, right? And so you're going to have to look at the Texas law, the Texas statute that we went over before. If you have been living in Texas for at least 6 months, and if you have been living in Harris County for at least 90 days on the date that you're filing your petition, then Harris County would be your venue to file your court that you're going to be filing your case in, right? And so then from there, you're going to draft your petition. get your divorce petition filed with the court. Then you are going to have the respondent served with your petition, or if it's an agreement, you can have the respondent file or execute and file a waiver of service. Make sure it's a valid waiver of service. Make sure that you're not having the respondent's not signing that waiver of service the day of or before your petition has been filed. All right, and so once the respondent has been served or a waiver has been executed and on file for the appropriate number of days, then you can, start thinking about finalizing your case. I know we discussed some of the other things like children issues and property issues that also need to be included in your divorce case, but those are things that you're going to include in your divorce decree. And we also have your divorce decree that you're going to have to prepare and file, along with certain closing documents that we really didn't get too much into, like your BV or Bureau of Vital Statistics forms and child support forms and record of support. And so you make sure that you're filing those with the court in order to finalize your case. And then you want to either submit a prove-up affidavit if it's an agreed case, or you want to get into the court for your final hearing on a default or a final trial in order to present your testimony to finalize your case. And then after you had your hearing, make sure the judge signs your order. Yeah.
But you can't have the hearing less than 60 days after you've already filed.
Yes, you want to be cognizant of your timelines. And so as far as the timelines are concerned, once the responding party is served, remember that he or she will have until 10 a.m. on the Monday following the expiration of 20 days. So we count 20 days on the calendar. That very next Monday at 10 a.m. will be the deadline for you to file your answer before a default can be executed. But remember, in Texas, we cannot finalize our divorce cases anytime before that 61st day. All right, so 60 days or less, then you won't be able to finalize your divorce case unless it's an annulment, or if there's an allegation of domestic violence or physical violence, or there's an active protective order or emergency order in place.
Okay. I had another question, but I want Myra to get to hers first. I see she put her hand up.
Yeah, what if we have a lot of our active soldiers and heroes that are out of the United States, and both husband and wife are active in the armed forces? Where would it be? Where would they file? Would they file wherever they're at, or
no? And that's a good question. For purposes of domicile, because we do have that a lot with the military personnel. They are stationed here, there, and everywhere, but it's not necessarily where you're located. It's really where you're considering your domicile to be, your residence to be. Okay. And so if your permanent residence is here in Harris County, but you are serving in the military out in Louisiana somewhere, you would still be filing your case here in Harris County because this is where your residence or your domicile is.
Is that relative to somebody that's not in the military, but one of the spouses lives out of state? So if you're here and you've been here as a resident for a year or 2 or 3 or whatever, but your spouse is in another state, can you file divorce here, or do you have to file in the state where you were?
Well, I mean, that depends on whether or not you're able to present enough evidence to show that the court has jurisdiction to even hear your case out here. If that party, since they're a non-resident, they have a marital residence out here in Texas or in Harris County. Have they ever been out here in Harris County? Because what the courts don't want is for, have a situation where the parties were, say, living in Louisiana as husband and wife, you pick up and move out here to, Houston, Texas, and then try to file a case out here. There's nothing out here. The other parties out there in Louisiana, maybe the children are out there, maybe there's property out there in Louisiana. This would not be an appropriate forum for you to file your case in a situation like that.
Okay, there was a question that came in here directly to me. Can you motion for default divorce judgment and deal with the permanent child custody and support stuff later?
Oh, you mean like separate the issues?
Yes.
Courts don't really like to sever those issues. When you're doing your divorce case, typically the court is going to want to consider and decide on all of the issues, the property division, the child custody and child support and all that in one case. Unless there's already been a case where the children issues have already been decided in a prior court order. In a situation like that, you can maintain your prior court order and just merge it into your divorce case. But otherwise, the court is certainly going to want to decide those matters together.
I was told by an attorney that you couldn't even file a divorce decree if there are children within the marriage that was not included in the decree, that the child support order had to be included in the divorce decree.
You mean like a prior child support order?
Yeah, a child support order had to be included in the divorce decree if there are children within the marriage.
Yes. Whether there's a prior order involved,
Yeah,
or you're trying to establish child support, then that needs to be included in your divorce case. That's what I'm saying. Like, you can't just sever those issues and decide like, we're going to do property issues and finalize the divorce case now, and we'll decide the kid stuff later. You can't do that. You cannot do that. The courts usually don't like to sever those issues. Only time I've ever seen the court sever the kid issues from the divorce itself is when there's a situation where the child was conceived with a person that's not a party to the case, basically. Like if the mom had a child with a person that's not the other spouse. I have seen it where the courts have allowed those issues to be severed, but usually the court wants to keep all those issues together in the case.
and I know I probably may be outside of your area here, but what happens if you're trying to do a divorce pro se, and you've got a child custody issue where the child does not want to live with or visit with a non-custodial kind of parent? Can you still, or do attorneys then have to get involved at that point?
Well, yeah, that's a separate kind of issue. That's almost like we're talking about a situation where there's already a court order in place, perhaps, and the child doesn't want to do the visitation pursuant to that court order.
Yeah. How do you finalize a divorce in that regard?
Well, I mean, I've seen cases where the children don't want to do the visitation, and the judges have just said, well, they're kids, they don't get to make that decision unless there's got to be some good reason as to why that visitation is not being executed, especially if there's already a court order in place, right? But usually what I've seen in the past, the judge, especially if it's an enforcement type issue, will say, well, they're a child, you're the parent, you're supposed to be making sure that visitation is taking place, regardless of what that child is wanting to do. Because we have that situation all the time where we have, a lot of times as teenagers, they don't want to go and visit the other parent.
Right.
And what I've seen happen is that the non-custodial parent will have to file an enforcement action against the custodial parent because the child doesn't want to go. And the judge has still ruled like, okay, this is a contempt action, that you should be held in contempt because you still need to be encouraging that visitation to take place. Child doesn't get to decide. We've already got a court order in place for that visitation. The other parent is entitled to it.
Okay.
Yes, you are amazing. Thank you, Ms. Angela.
You're welcome. Were there any other questions?
Yeah, there was another question. I'm going back to the registration sheet that somebody had asked about property and if the other person can't be found when they're doing the divorce pro se. I want to make sure that I get to it here. Okay. How do you file for divorce when there is property in both names, and neither party is willing to give up interest? Well,
if neither party is willing to give up interest and y'all can't come to an agreement, then you're asking the court to make a decision. And say, for instance, we're talking about a residence, right? A house. A lot of times the courts will default to just sell it and split the proceeds, because the court's not going to, get into, unless there's other property that can be used to balance it out. Sometimes that's not even the case. And a lot of times the judges don't even want to get bogged down with all that. They will just say, because it's easier to just say, sell the property, split the proceeds.
Okay. All right, I think that's all I had. Are there any other questions of any other participants? And again, this was a lot of information.
I know. And I tried to keep the information tailored down to, the basics, but it's still
Yeah.
alive when we're talking about this process for filing for a divorce, which is why I'm glad that y'all had this, because there's so many questions, and it can be such a long and stressful and cumbersome process if you don't know what you're doing.
Well, after.
Mhm.
We're
Go
gonna
ahead.
ask you back, because I know about 90% of everyone that's watching it right now, or it's gonna go to Facebook Live and watch it, they're gonna have, oh, wait a minute, I forgot to ask this question. So we
Yeah.
just like to have you back at least within 3 months
Oh
into
yeah,
back through it again and
absolutely.
for all questions.
I would
Or-
love
or
to come
part-
back and do a follow-up, you know,
Or
especially if we
part
have
two.
part two. I would love to do that, especially if we have additional questions that come up after the fact, because that's always the case, isn't it?
Yeah.
Because you get the information, you start thinking about it, and like, what am I supposed to do here? Especially if you're in the process of your divorce case. A
Yeah.
lot of times those questions don't come up until the issue arises. And so I am more than willing, I'd be happy to come back and do a part two, a follow-up, so that we can get those questions answered.
Mm.
A lot of times we're meeting with our community leaders. They'll say, okay, I saw this virtual workshop. I understand this, but I have this other question. And I'm like, men are not the legal experts. Having Miss Angela back, we definitely will give you all the details.
Absolutely. Just let me know when.
In one of our home bar classes, the counselor always has the follow-up question. What is it that you know now that you didn't know before you started this class? One person raised their hand is that I know now that I need to get a divorce before I buy my house, because I don't want this other person to be entitled to the property that I
And
have.
what I will also add to that, and that I've seen people do quite often, and don't do this, if you are considering buying property and you are in the middle of a divorce, just wait.
Yes.
Just wait.
Yes.
You don't have to, you don't have to buy that house right now, because if you do it now before your divorce is finalized, then you're looking at having to buy that property, right? So just wait.
That reminded me, for separate property, but the funds have been commingled to pay for separate property. That brings up another issue with technically what's considered separate and now community property.
Yeah.
So if you had property that was purchased before the marriage, or you have a house, but now the spouse is actually paying the mortgage or contributing to the mortgage.
Yep. Yep.
What does that do in that scenario for that property?
Well, that means that the property has benefited from the improvements from the community estate, right? Or
Right.
the separate estate of the other party. And so that means that the party who's paying that mortgage, whether it's with their community funds or the funds that they have acquired before the marriage, they would be entitled to a reimbursement. You know, so they would have to plead for it. They would have to track those funds. They'd have to, do all the necessary pleadings and present the evidence to the court, but they should be entitled to a reimbursement for that money that they put into that separate property to improve the separate property of the other party.
Exactly.
So there's remedies for it, but you're gonna have to do your own work in order to get there. And that it may be beneficial to get a pro bono or a hired attorney if that's the case. Or some people are very well versed in filing and preparing these documents on their own. So you never.
So when you've got separate property, keep your funds separate when you're maintaining or doing anything with that property.
If you're gonna have your separate property.
Yeah.
If you want to avoid having to pay a reimbursement back to the other party for improving upon your separate property, then keep it separate. Just keep it separate.
Oh, somebody says I'm looking forward to the next section. Should be called "What You Should Know Before Getting Married and Having Kids."
Especially in Texas, yes.
That would be great.
Especially here, because we have our own way of doing things, don't we?
Indeed, yes, indeed. So thank you so much,
You're
Ms.
welcome.
McKinnon. This has been extremely informative. We definitely appreciate you taking the time out to provide
Absolutely.
all of this information to the community, and we look forward to having you back for part 2 and what you need to know before marriage and children. So
Absolutely. Just let me know day and time.
We'll definitely do. Thank you guys very much. For those that are, again, that are viewing us on Facebook Live, if you are interested, or please feel free to go back and watch this presentation again. For those folks that did register, we will be emailing a copy of a link so that you can go back to view this presentation again, along with these resources for pro se litigants, if you guys are interested in trying to complete your divorce on your own. So look for that information to come. Also, following this presentation on the screen, you will see a link to a quick survey, basically just kind of asking what it is that you thought about this presentation, if there's more information that's needed, or if there are presentations that we don't currently offer that you all may be interested in, then please let us know. That's the only way that we're able to continue these types of presentations and to evolve and know what it exactly is that is important to the community. So definitely let us know. Once again, thank you, Ms. McKinnon. We appreciate it. We look forward again to having you back, and for all of the participants for joining us again for another A Month of Service presentation. So you all have a wonderful afternoon and remainder of your day, and we'll see you all next time. Thank you, Ms. Myra.
Thanks, everyone. Have a great day.
Have a good one.
Bye.